We are going to be... Sorry. Okay, the recording started now. I'll officially start. So we're going to be talking about corporate restructurings. For those of you that don't know me, I see quite a few familiar names on the list. So yeah, for those that don't know me, my name's Helen Gerrard. I'm one of the partners at Ignition, and I head up the corporate team and also the corporate finance team. And joining me today, Karishma, Martin, would you like to introduce yourselves?
Yeah, sure. So, hi, I'm Karishma Naravane. I'm a senior corporate lawyer at Ignition Law, and yeah, I work with Helen on all sorts of corporate matters.
Yeah, and good morning from me. My name's Martin Brown. I'm the CEO of Elephant's Child. We're working very closely with Ignition Law on a number of clients, and specifically focused around exit and growth and access to funding. So, Helen, Karishma, looking forward to today's talk.
Thank you, Martin. So what are we going to cover today? We're going to cover corporate restructurings, why we do them, types of restructurings, the key legal considerations, timing, and then any final thoughts. This session is going to be quite interactive, so if anyone has questions, please don't be shy. I don't bite most of the time, unless my children have kept me up all night, which is most nights. So please do feel free to ask questions. And there are a number of topics that we will be covering that really could actually have a session in their own right, because we could literally go on for for hours talking about the different ways in which things can be done and the issues that come up. So if anyone does want a session specifically on one of the topics that we cover, and we can perhaps look at doing another session that focuses specifically on that particular topic another time. So why do we do corporate restructurings? There are a number of reasons, really. So a lot of our clients will come to us and look to do a restructure because they are looking at expanding into different business areas. So they're looking to increase the business efficiency and create different, essentially different arms of the business. And so the way, or an easy way to do that, is to set up a company for the different types of businesses. People might look to do it before or after an acquisition to make it more efficient. So to give you an example, one of our clients underwent a big restructure some years ago now. Everything was held in an LLP, that's a limited liability partnership. And what they decided to do, and this was tax driven to a degree, but also efficiency for the purpose of an upcoming sale, they created a new limited holding company. And then under that limited holding company, there were various different limited companies, each of which had a different business area. So, for example, they were involved in merchandising. So there was one company particularly for merchandising, another for a different part of the business, and then another for another part, etc., etc. And then they actually sold off one of the businesses, and so that made it quite easy to then sell that part of the business to the buyer. There's also tax considerations. This is probably more Martin's degree. Martin, I don't know whether you have anything to add on that front.
Yeah, it's interesting. So to pick up on a couple of those themes, Helen, so tax and getting ready. We're seeing an enormous impact as we approach the tax year end around business asset disposal relief. So people's lifetime value sits at £1 million now, and that is currently taxed at 10%. As of the 6th of April this year, that rises to 14%, and then of April next year, that rises to 18%. And then the amounts above that have already lifted to a 24% tax rate. So when we think about restructuring and tax and getting ready for sale or acquisition, they become material in people's thinking. I'm modelling the net impact of all of those effects, and therefore structuring to get the most and greatest tax efficiency.
And just to sort of add one point on the tax, usually, as Helen mentioned, tax is a key driver when it comes to any type of structuring of corporate transactions. But even where we have clients where, you know, tax is not the first reason why they're thinking of moving things around and do a corporate restructuring, it's really important to check around the tax in case there are sort of adverse consequences that might come up because we're doing sort of moving groups around or businesses around. There may be tax that plays out, so it's worth checking that it's all okay for tax based on sort of whatever structuring we're doing.
Thank you. So the types of restructurings, there's various types, from just, you know, simple transfers, so share asset transfers, to kind of more complicated ones involving share for share exchanges, management buyouts or MBOs. So if we mention MBOs and we're talking about management buyouts, they can have various complexities because often you are doing share for share exchange as part of it, or some form of you'll see that it's mentioned Delaware flips, but it might not necessarily be Delaware, but you might be moving investors up to a new topco, and that might involve having to move a share option scheme, which has other complexities linked to it. We have demergers, other reorganizations, you know, converting from an LLP to a limited company, and debt restructurings, which we'll touch on very briefly later.
Yeah, just a thought for me on that one, Helen. The business I'm with today is starting to restructure. And the rationale there is we've got a really solid business here. What we're doing here is we're putting in a top organization. We're separating out where the building asset is owned, separating that from the existing trading company, and then starting up a third trading company, which is more a direct-to-consumer business, whereas the other one is more of a business-to-business. So we're starting to get that structure in place at relatively early stage, thinking about what the future might hold for the founders and shareholders of that business. And I guess a critical thing for me, which is an emotional thing rather than a legal thing, is actually the great thing this business has done is they've started to think about what the future might look like, how they set a different foundation today, and rather than hope or wait or maybe get overawed by all of the market stimulus, they're actually setting out the business in good time. And you know, exit isn't something that's on the horizon for this business. It's just about doing the right thing for the organization today. So getting started and thinking about restructuring and how that links to your aspiration is a really critical moment for us.
Yeah, I think that's it. Sorry, Karishma, I was just going to say, you know, preparation is key for sure, and having the, you know, the right advisors involved. Like, the sooner you can get tax and legal advice, and I'm not just saying that because it's obviously good for us, but yeah, the sooner you can, the better. Sorry, Karishma, you were going to say something.
Yeah, I was just going to say that Martin's example actually reminded me of an example which went in the other direction. A few years ago, I was acting for a large healthcare company which was trying to sell their business, and they had two parts of their business, and they found two different buyers for the two different parts of their business. And because they hadn't actually separated it in advance and done the preparation that, Martin, you're doing with your client, when it came to the sale, everything got a bit muddled. And so what we had to do was we were acting for them, and we had to sort of do a lot of internal transfers to make that restructuring work. But then all the internal transfers were looked at with a much sort of higher level of scrutiny, because the external buyers were interested in all of the warranties that went across the different subsidiaries. They were interested in the timings. They were interested in sort of everything that backed up that internal transfer, which otherwise, if they had prepared beforehand, maybe seen it through for a year or so, and then, you know, could give comfort to the external buyers that, right, it's all been fine. You haven't had to go and make claims against anything that, counterparties haven't raised issues. It would have been much simpler and easier. So I had that sort of mess to deal with because of that lack of preparation. So it just reminded me of that example, and it's such an important point.
Yeah.
Exactly. Okay, so the simplest restructure is essentially sort of intergroup share transfers, asset transfers, and business transfers. So you might want to do this in order to kind of move assets around, segregate assets into particular entities. You might need to move employees around. You might have a situation where you're branching out into a different jurisdiction, and so you need to employ people in that jurisdiction, and it's easier to set up a new company in that jurisdiction, and so you would then transfer certain contracts and assets across to that particular entity. So this is probably the simplest of them to a degree. That's caveated by the fact that obviously if you've got other jurisdictions involved, then you've got local laws at play in those jurisdictions. And if you are moving employees around, it's really important to remember that an employee, even if they are a UK national, if they're going to be based in a different jurisdiction, then you need to comply with the local laws of that jurisdiction.
Yeah, I think just one point to sort of pick out on the difference between asset transfers and business transfers, because that comes up quite a lot in some of the transactions we deal with, is that in an asset transfer, you're picking out certain, cherry picking assets to move across. So if there are only certain things that you want to move, like IP or particular property or certain assets that the company has, you can transfer just the assets. When it's a whole business, the business as a going concern being transferred, then it's a business transfer. And it might seem like sort of semantics, but it can play out, especially in the context of employees, because the 2P legislation applies where employees can automatically have a right to transfer across if the business is being transferred. So it's always worth thinking about whether it could be categorized as a business transfer, even if the intention is to do an asset transfer, to just sort of do that analysis to make sure that the liability around employees is what you intend it to be.
Yeah, I think it's a great point, Karishma, isn't it? And the point about clarity is a very real one here. We're involved. In fact, we concluded last Friday on a transaction that Helen knows a little bit about. In extraordinary circumstances, our UK client has acquired a Belgian supplier of some software. So if you ever get me over a coffee or beer, I'll tell you more about the story. I can't divulge too much here, but truly extraordinary circumstances. It's a deal that's worth about 360k euros, but the software is really important for our client. What they are specifically buying in this case is the software code, the intellectual property that surrounds that, and the operator that is responsible for driving that. That is the only thing that they want to buy in this situation. They don't want to take on any other assets, any other liabilities, or indeed the shareholding of the business. So really important to think about actually what is the transfer here, and specifically what is the asset or the business piece that you're looking for.
Which then takes us on to kind of a bit more complicated steps, I guess, with hiving up and hiving down. So this is where we're talking about transferring from subsidiaries to parents or vice versa. Karishma, I don't know whether you want to take this one.
Yeah, I think it's just terms that we see used. So we thought we'll just break it down in terms of explaining what a hive down or a hive up is. A hive up is sort of commonly used to describe a restructure within a group of companies where the net assets or business of the subsidiary are transferred up. And then a hive down is the opposite, where it's transferred down. Now, it's just worth noting that the legal processes around the two are different, and although you're doing sort of the opposite thing, creating a subsidiary and moving things to a subsidiary is much easier, more straightforward for both tax as well as company law issues. Whereas if you're moving things up, so there'll be more steps required. So if you need to put in a holding company or an intermediate company as part of the group, it needs to be, a new company needs to be created. Everything underneath it needs to be sort of moved across. And then if you're moving assets up or subsidiaries up, then there are things like distributable reserves that would need to be looked at from the company that's transferring point of view. So that's something to bear in mind. A share for share exchange comes into, you know, this category type of hive up. So just sort of wanted to contextualize, because oftentimes we look at a structure chart and we're like, right, let's just put one new entity here and then this will solve the problem. But there are other things to take into consideration and bear in mind.
Yeah, I think from our side in the small to medium enterprise space, where you've got around 5.6 million business owners that are very focused on their particular domain, their particular area of expertise, and often are very good at that. But the wider sphere of running a business and thinking about these hive up and hive down scenarios is alien to them, and it takes them a long way away from where their passion or their expertise might be. So I think thinking that through in layman's terms, understanding things like control and power and how this needs to form part of a wider strategic plan, and then making sure you've got all of those necessary trading agreements in place is absolutely critical. Not losing, of course, why you're doing it in the first place, which is something I'll come back to in a bit.
That leads nicely onto founder exits and MBOs, management buyouts. Remember the key word that we were talking about? These seem to be quite popular at the moment, and lots of people are trying to get it done before the end of the tax year, as Martin said earlier, and particularly on the MBO front. I think, you know, they're particularly sort of small family-run companies where, you know, they've got a key employee or management person who's been with the business a long time and you know, want to continue working, but they've got the older generation who are looking to retire and obviously want to take advantage of the tax relief. So that's why there's this big push to try and get everything done before the end of the tax year. So we're finding that to be quite common at the moment. But yeah, in terms of the restructuring aspect, sometimes these can be contentious when we're talking about founder exits, because it might be that you know, it's not a friendly situation where a founder just wants to leave because you know, they've you know, run their core of the business, or you know, they're looking to do something different. You know, they've given their all for 5 years and now they're ready to do something else. It actually might be a situation where the other founders need to get this person out and they're causing a hindrance to the business. So we see both situations, and this is when we have to bring in our wonderful litigation team to help, because certainly with the settlement agreements that need to be put in place, they can have quite complicated leaving provisions, and it's important to ensure that all claims are released upon completion of the settlement agreement. So so there's lots of different aspects that come into play. And in terms of the restructuring, it might be that you know, a founder, you end up agreeing that a founder can keep a particular portion of their shares. However, we change it into a different class of shares, for example, or perhaps there is an agreement whereby within a particular period post completion, their shareholding gets reduced and it gets bought out. It might be that not all of it gets bought out, but there's lots of different situations that you can construct. It's not necessarily driven by legal provisions, yes, of course, we need to ensure that the legal documents work, but ultimately this does come down to a commercial negotiation as to what can be agreed. And there's similar things that come into play with MBOs as well. With MBOs, it might be on very friendly terms because, as I gave the example, somebody who's been with the business a long time is wanting to buy the retiring, retiring-ish founders out. It might be that they stay on with the business a little bit afterwards, but essentially they are looking to enjoy their retirement. But you have different things to factor in. There's also potentially conflicts of interest. Whilst everyone can be aligned, you do need to always consider the possibility that things might go wrong. And I always liken it to when you get married. No one really wants to think about the possibility of divorce, but we all know it does happen, and it's almost like a prenuptial type arrangement. So it's important to ensure that you have all your ducks in a row.
Yeah, founder exits for us are a really hot topic at the moment. We're certainly seeing an increase in management buyouts and also employee ownership trusts, or EOTs as they're called. So I think MBOs and EOTs are becoming increasingly commonplace by way of affecting succession, amongst other things. To your point, Helen, you would expect them normally to be simpler and more amicable. And actually that's what you hope for, but in many cases they're not, for various reasons. So I think, my emphasis here is not to underestimate the importance of a really good shareholder agreement and clauses like good leaver and bad leaver and drag and tag and valuation methodologies, because like with all exits or transfers of ownership, you do need a willing buyer and a willing seller that ultimately need to agree on a valuation. So I think really good shareholder agreement, worth revisiting if you haven't done that for a while. Thinking also about governance of the business, because again, in SME world, we deal with a lot of directors that might be oblivious to Companies Act 2006 and their powers and their duties and their obligations of care around that. And the other thing, to your point around divorce, Helen, it does get you thinking about actually what is the suitability and capability of the incoming leadership team, who may well be good managers, but actually are they good leaders and directors? And that's quite a different thing. So for us, again, MBOs and EOTs, increasingly commonplace, understand the differences of those mechanisms, both from a taxation standpoint and your future position. They are relatively quick to construct. You do need to agree on a valuation. You also need HMRC to ratify that. But ultimately, where does that lead you and the incoming leadership team? Really hot topic and well worth exploring.
Yeah, I guess totally agree. And just sort of picking out on the valuation point and conflicts that Helen mentioned, I think one thought was that managers are making that transition from being employees to owners, and that may not be easy for everyone. There may be conflicts where you're thinking about sort of the best price for the asset, and if there is an asset sale in the MBO, and a potential conflict of interest is if the existing management team is sort of looking to bid on the assets or operations that are being divested. And so they could sort of deliberately sabotage the future prospects of the assets that are for sale and try and buy them at a relatively low price. We've seen this happen recently, and it's sort of managing those conflicts and thinking about that as well. So I absolutely agree, sort of trying to put as much as possible in the legal documentation, but also being conscious of the fact that everything is not sort of driven by legal, it's commercial as well. So sort of thinking about what people could do in the background.
Yeah, and it's always worth reminding people that if they're also directors of the particular companies involved, then they have to act in accordance with their fiduciary duties as directors and ensure that they're acting for the benefit, in the best interest of the company, for the benefit of the members as a whole. So it's really important from our perspective to keep reminding the management of those duties if we are acting for the management. So yeah, I mentioned share for share exchanges and Delaware flips earlier. These are actually quite simple, really. Essentially, it just involves exchanging shares in one company for another. And the reason why we've specifically noted Delaware flips is because a lot of people do this, where they basically insert a top co above their already existing English incorporated company. And the reason why they might need to do this is, for example, they start out with an English incorporated company, and then as they're marketing the company and trying to get investment, the investors actually tend to be, or they happen to be US investors, and they've specifically said, actually, no, we want to invest in a US company because we get particular tax relief if we do an investment in a US company. And so that's why people will often put in place a Delaware Topco above the English incorporated company if we're talking about a Delaware flip. So yeah, and the reason why it's Delaware is because Delaware is really easy to do in the US compared to some of the other states. It's very straightforward. So that's one of the reasons why people do it. It might be that you have investors in different companies and you're trying to concentrate investors in one place, and so you essentially will put in place another entity and do a share for share exchange. I mean, and the reason why I've noted tax advantages here is, because there are tax advantages for certain investors depending on where they're based and what types of companies they're investing in. Yeah, so that's the reason behind those.
Yeah, just one for me here, Helen. So this is a UK business that we're dealing with, started and founded in the UK. Subsequently, they've added French, Italian, German, and US subsidiaries. They're currently looking at an acquisition which is in Canada, and we believe that a lot of the growth will then come from North America, and ultimately the acquirer, who could be 4 or 6 years away, is more likely to be from the US. So we're in exactly that mode at the moment, thinking about making this acquisition and then doing exactly what you suggest here in that Delaware flip, and really setting the business up as a North American business going forward with the end game in mind.
So reorganizations and demergers. Yeah, I mean, this is linked to what we were talking about at the start, where people put in place different companies for different types of business areas, and so you might be trying to reorganize and essentially demerge some business areas. You might have a business area that isn't actually that profitable, and so it's easy to just segregate that out and either move it out of the group or make it dormant if in time if it's not profitable at all. And it's also a way of essentially limiting liabilities within particular business areas. So essentially it means that a business can be more saleable. Martin, Karishma, I don't know whether you want to add anything more on that particular.
Yeah, I think from my side,
yeah,
go on, Karishma.
No, I was going to say nothing much from my side either. I think when it comes to a demerger, there is a particular process that needs documentation. So as Helen earlier said, each of these topics can have a session of their own. So we won't get into sort of too much detail around it. But a demerger process, we'll have a demerger agreement and a particular sort of process and timing around that. So if you're looking to do that, then we can have a separate session, or you can reach out to us.
Yeah, my head goes to 2 areas, I guess. One is around intellectual property, which is often overlooked. And the second is around the physical assets. So you've got a trading company and a property. You know, how do you separate or demerge those two entities?
And so, yeah, we thought we would mention LLPs to LTDs, limited companies. This was quite a hot topic some years ago, where lots of people were converting from an LLP to a limited company. And in fact, Ignition did it as well. And it is actually a relatively straightforward process. The documents can be complicated depending on what's involved, but essentially, to go from an LLP to a limited company, you just need to set up a new limited company, change names, and then have an agreement where you transfer the assets and business from the LLP to the LTD, and dissolve the old entity. And to go the other way, from a limited company to an LLP, it's essentially a very similar process as well. And not many people go the other way. However, I have had somebody reach out on that. So I'm talking to them in a couple of weeks to chat through what they would need to do. And I guess the reason why people would want to go from a limited company to an LLP is an LLP does provide more flexibility to a degree in terms of, you know, if you have a particular waterfall of payments that you want to do, it might be easier to structure it with an LLP structure rather than a limited company. That might be a simpler way to do it. You also need to think about any you know, internal approvals that you'd need. You know, substantial property transactions is quite a key one in this area.
Just one sort of thought on this. Sort of recently, we've had a number of clients trying to move from LLPs to limited companies, also because of sort of early stage companies who are looking for funding. If they're going through the EIS, SEIS route, then that's available to limited companies rather than LLPs. So if they're in that position, then you know, they were initially maybe advised to have an LLP for certain reasons of maybe its ongoing reporting requirements are a bit simpler, but overall, as Helen said, most companies sort of move to that route, move from LLPs to limited companies, and fundraising has become a common criteria for that.
Yeah, just a couple of thoughts based on our discussion last week, Helen, about when you're making these transitions, considering wider things. So one that we touched on last week was regulation in your sector and critical customers or suppliers in your sector. And what does that change mean for each of those things in terms of regulation and control? And then the other thing, again, just to repeat myself, but as a business owner, keeping your aspirations in mind, if you're changing from LLP to limited, why are you doing that? And how does that deliver to your personal aspirations down the line?
Yeah, exactly. And that leads us on to the final one, I think. Yes, debt restructurings. So this could be a whole session in itself, but we just thought we'd briefly touch on it because actually when you Google corporate restructurings, this is what comes up. So but I used to do a lot of this back in the day of the recession of, you know, the 2008, 2009, 2010. And debt restructurings essentially involves renegotiating the debt, sometimes novating debt from one entity to another. You might have new security considerations if the debt is secured, and you might have various lenders at play. You might have senior lenders, mezzanine lenders, and so you need to ensure that that they are all on the same page and are involved in the discussions. And linked to this is acquiring assets out of administration, which we come across quite regularly as well. So so if you have a company that's that is in an administration process. The liquidator might be looking to sell off the assets to at least recover some value from the company for the shareholders and the creditors, mainly the creditors. There's a different process for acquiring assets out of administration, because you can't really negotiate the documents so much. But as I said, this could be a whole new topic itself, because there's just so many things that we could talk about.
Yeah, so notionally a record year for insolvencies, Helen, and liquidity being tight generally. You know, we are used to seeing a legacy position where businesses have a patchwork of capital structure. You know, pandemic, for example, they've got a bit of CBILS, a bit of bounce back, a bit of invoice discounting, a bit of this and that. So whatever that patchwork is, it's useful to think about your business in terms of the next 10 years, more specifically, strategically, where's it going in the next 3 years? And then on a very granular level, what does the next year look like? And if you can model financials around that, you can get a sense as to what is the best capital structure, and then start to think about resetting or refinancing what you have in place. And then to pick up on another one of your points here, the notion of acquiring assets out of administration through a pre-pack or whatever that vehicle might be, is a very real challenge, clearly, for the distressed business, but it also does represent a big opportunity for growth in this current marketplace. So lots to think about around debt restructuring.
So key legal considerations when talking about restructurings. There's various things to consider. You might have third-party consents that are needed. That could be, bank, lender consents, regulatory. For example, if an entity is FCA regulated, then if there's a change of control, you may need to get, you will need to get FCA approval. There might be HMRC consents involved. Other things to consider, company law issues and what shareholder consents are needed. We mentioned substantial property transactions as well. Karishma, I don't know whether you want to jump in at all. I'm conscious.
Yeah, I think I covered most of it, Helen. I think the only thing I would add is on your point about company law considerations, the consideration of the price that's involved in the transfer should be looked at carefully, and because that could lead to company law issues. So oftentimes, if it's an internal transfer, you're looking at sort of book value, which may be less than the market value, and sometimes sort of even less than book value. So you've got to sort of look at distributable reserves considerations, because there may be company law issues that lead to sort of penalties, void transactions, and clawbacks. So that's really important, and sort of the market value will need to be determined with respect to what a buyer or seller would be expected to pay, based on sort of an independent third party for the assets. But oftentimes internal transfers companies are not sort of willing to spend that money on getting a market value. So you've got to think about your director's duties and see if you can justify the value based on accountants' views and things like that. So it's one to bear in mind and be conscious of when you're doing transfers to avoid company law issues.
Yeah, and I think for me, this really emphasises, and we're just trying to be the elephant in the room here, excuse the pun, but what I've referred to as real issues versus created issues, and that is having good legal and tax advice around you. We recently got into a battle as a part of an exit due diligence program, where the other side, with their very well-paid advisors, were trying to take us to task around IR35 and UK VAT, and actually they were wrong. And it wasn't. It was a legal consideration. Their point was they were trying to discount the value of the business, and our point was actually the position we'd taken. It was very real. and legally justified. So when you get into those kind of commercial debates, it's really important to know what the correct legal and tax position is, and where the other side might start to push you around just trying to create a better commercial value proposition. And the other thing I would say is, again, thinking about a change of ownership here, in an ideal world, it would be great to have long-term exclusive contractual relationships with suppliers and customers. Often that's impossible to get. So sign off from customers around the strength of the relationship is a really important thing to have. And to have that, you have to have both strategic and tactical relationships with your suppliers and customers. So that's worth thinking about over time. So in a sense, balancing really solid legal and tax advice with good cultural and commercial decision making.
Yeah, I would agree with that. And actually, that's a good point on having good relations with your customers, because your customers, your suppliers, sometimes there might be termination events in your contracts with them, so that if there is a change of control, they have the right to terminate the contract, and there might even be a penalty payment that's due in respect of that. So being able to have a transparent conversation with them and negotiate that will be key to reducing any liabilities that you would incur. We thought we'd mention the National Security and Investment Act, because this is quite a hot topic at the moment, and applies to, it doesn't just apply to external transactions, but also intergroup transactions. And so if you are doing a sale, or it applies even in fundraisings, if somebody's going to go above a certain percentage, then it is something to consider. And it could be that it is a condition to you being able to proceed. It might be that you don't necessarily need approval. It might just be a notification procedure. However, please be aware of it, and you should seek legal advice on this before proceeding.
Yeah, I think that's nothing much to add on that, Helen. I think it's just be aware of the fact that it applies to intergroup ones as well. The guidance on this says that it will be rare, but there may be those rare cases where an acquisition of control over an entity by a person in the same group does raise national security risks. So it was, when the government considered whether to make an exception for intergroup transactions, they considered it and rejected the approach. So it looks like that's a law that's here to stay, and we should just be mindful of it, even if it's only for those rare cases that this applies. And as you said, if it does, then we'll have to sort of think about notifications or consents and precedent because of that.
And that leads us on to, I think this is our final slide, actually. Yeah, process and timetable. Karishma, did you want to take this one?
Yeah, I think it's just a quick run through of the process for most internal reorganization transactions. You do the diligence first. It's usually simpler than an external transaction. One point to sort of draw out there is employees. So if there are employees that are transferring on an asset or business sale, think about the automatic transfer legislation, which is TUPE. Also, sort of the buyer will step into the seller's shoes as regards of the employment contracts of the transferring employees, and inherit all the rights and obligations. So even if it's sort of within the group, it may be different if there are different jurisdictions and subsidiaries involved. And then pension scheme obligations as well. So that becomes, again, linked to the jurisdiction that these employees are in. So diligence will involve sort of all of that, as well as depending on what the assets that are moving. There may be property, there may be IP that you need to look at. Then consents and approvals. There may be consents like HMRC or external regulatory consents, which would apply in case of a share sale. or an asset sale, but largely share sale. For an asset transfer, the consents are for sort of on assignment. There may be notification requirements. There may be consents required depending on the assets and registration requirements. Like if you're transferring an IP, then that may need to be registered with the new owner. So you sort of have to think about all of the different types of consents that are required, and then board and shareholder consents. It could be sort of for all of these kinds of transfers anyway. The documentation, the key documents are usually an asset purchase agreement or a business transfer agreement or a share transfer agreement. If it's a demerger, then a demerger agreement or a share for share exchange. So depending on the kind of reorganization we're doing, the documentation would have to be linked to that. It's a little bit tempting to keep it simple. Sometimes we have clients saying, oh, we've done this transfer, we've not really documented it because it was all intergroup. But we would sort of strongly advise you to consider having good legal and tax advice around it and document it properly, because at a later stage, there may be an external buyer who looks into the documents. There may be HMRC and other external sort of authorities who would want to see clear documentation. So it's really important to make sure that that's in place even for simple intragroup transfers. And then finally, once you've got to completion, exchange the documents. If there are any conditions, then met those, and then move to the post-completion side. It's things like thinking about announcements, application for tax reliefs, and dealing with sort of registration of IPRs and land registry matters. So more of the sort of operational and practical aspects come into play after the completion stage.
I didn't have anything else to add on that. Martin, did you have anything from your side? I mean, obviously.
No, just to support Karishma's view there, Helen, I think just around this, to manage your own sanity and expectations, a bit of pragmatism, because there are these third parties, external regulators and consents that you need. And with the best will in the world, you can't control their responsiveness. So it's a bit of pragmatism and allowing sufficient time and the passage of time just to make sure that you keep calm and positive throughout the process. There's lots you can't control here.
Exactly. The best will in the world, we cannot control everything. Did anyone have any questions?
Just wondered your view, Martin, on business asset disposal relief with what you're hearing on the ground. Obviously, as you were saying earlier, it goes up after April to 14. Are there any chatters about what might happen in the midterm? I know it's very speculative, but do you foresee it sort of, and from what I'd heard, it wasn't as bad as people were concerned in terms of capital gains going up and BADR going up, but do you think it might sort of drop down eventually again? Just thinking in the context of 10 years ago, it being a £10 million, 10% relief, and quite how far it's dropped, and noise of wanting the economy growing and people scaling up businesses in the UK to kind of bigger numbers. Do you think in the midterm it might come back a little bit?
You would hope so, Alex, but the answer is I'm not really sure. Like you say, that move from £10 million to £1 million lifetime allowance, and when you consider a lot of businesses that we have could be husband and wife type partnerships or other forms of directors, you know, that 4% increase is material in a lot of SME type sales. We would like to believe that there is some relief in the future. However, that budget was a disaster really in October for the SME world, and I'm not hearing much that's going to reverse that in the statement we're about to hear from Rachel Reeves. It is challenging because it's not the only impact that we're seeing in the space. You know, if you add in things like national insurance, increasing employee regulations, there are so many factors, notwithstanding the elections we've had and the geopolitical state that we see ourselves in. There are so many other factors that are affecting business leaders at the moment. I hope they don't do anything to business asset disposal relief, and I hope they don't change that 14 to 18%. I would think they would reverse that because that's the thing that's really going to drive growth. And when you think there's 5.6 million SMEs in the UK employing over 60% of the labour force, that bit of stimulus might just be what is needed to give people confidence to go back to growth as opposed to cuts that we seem to be thrust into at the moment.
Martin, thanks everyone. That was a super helpful overview. And I think the key takeaways are get sound legal and tax advice. And it's never too early to start planning if you're thinking about any kind of restructure or a founder exit in the future. Martin, I was wondering if you could elaborate a little bit more about employee ownership trusts, because I've seen a couple of them, but I'm not too familiar with how they work and what the main drivers are for putting those in place.
Yeah, so in headline, the EOT, I mean, the thinking behind it is about giving the staff, the employees, a chance to own the business. And I think, you know, that's in perpetuity, and that's a great thought and a great sentiment to have. If you're coming out of the business, if you're the selling entity, there is a huge tax advantage in that you don't pay tax currently. So, you know, that's very useful for the outgoing owners. There is a need then to set up a trust as well as to set up an executive board. So the trust to run the trust and the executive board to run the business. So ownership changes. I think the challenge I have with it is really twofold at the moment, Lauren, in that they are still relatively new and not many have been done. You're probably into a few hundred. I do worry about the test of suitability, capability for the incoming leadership team. Because what you wouldn't want to do is owners to sail away with a tax-free amount and then the business to be broken very quickly thereafter. So that would concern me in the future. I think there are benefits for staff, including if there are distributable profits. I think they can take around £3,600 each on a tax-free basis. I think one of the challenges with EOTs is I'm not aware of any significant precedent of actually selling the entity down the line. So you can reward yourself through earnings and remuneration, but you can't get reward through ultimately selling the business. Whereas in management buyouts, you certainly can. So there are pros and cons of each of those mechanisms. Hopefully that helps in headline, but it's a bit of a wider discussion if anyone wants to get into it.
That's helpful. Thank you.
Yeah, I don't think there was no chat conversation. So yeah, unless anyone has any other questions, we can give you 5 minutes back to your day. Okay, well, thank you very much, Martin, for joining us. Yeah, thanks everyone else for joining us as well.
Thanks, Helen. Thanks, Karishma.
Thank you.
Say goodbye.
Thank you. Thanks. Thank you.